morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today we're going to be providing another installation to our Federalist Papers series going on number 84. So if you haven't gone back and watched 1 through 83, I know they're on the longer side, but they're so incredibly important because one of the frequent criticisms from the late and great Justice Antonin Scalia about the modern legal education system is that they don't teach the Federalist Papers. Understanding the Federalist Papers, in addition to the Anti-Federalist Papers, will provide you a very well-rounded, advantageous understanding of the U.S. Constitution, and understanding the U.S. Constitution will absolutely be necessary if you intend to combat any sort of lawfare levied against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Federalist Papers. The version I am using is provided by the federalistpapersproject.org, but there are multiple institutions from which you can get a paper and digital copy of the Federalist Papers. Go ahead and get both. While you're out there looking, if you haven't already, go ahead and get a paper and digital copy of the Anti-Federalist Papers so you can join us in comparing and contrasting the arguments for and against ratifying the U.S. Constitution. Excellent. We're getting really close to the end of the Federalist Papers. We've only got this one, and then number 85. We'll do a quick recap, and that will be the close of the Federalist Papers series. It's been a long time coming, but been enjoyable nonetheless, and hopefully this information, if you read through it, plays greatly to your benefit. Okay, so number 84 is titled, Certain General and Miscellaneous Objections to the Constitution Considered and Answered. So now this one's kind of like his general remarks, but a general rebuttal. So it's written by Mr. Alexander Hamilton, published in the Independent Journal on Wednesday, July 16th, on Saturday, July 26th, and Saturday, August 9th, 1788. He says this. This is going to be another longer one, just like the 83rd Federalist paper, so go ahead and strap on in, probably get a snack, maybe something to drink. It's going to take a little while, but we'll get through it nonetheless. Anyway, he says this. The people of the state of New York. In the course of the foregoing review of the Constitution, I have taken notice of and endeavored to answer most of the objections which have appeared against it. There however, remain a few which either did not fall naturally under any particular head or were forgotten in their proper places. These shall now be discussed, but as the subject has been drawn into great length, I shall so far consult brevity as to comprise all my observations on these miscellaneous points in a single paper. The most considerable of the remaining objections is that the plan of the convention contains no Bill of Rights. So this one's a dilatory or negligible concern, yet it was raised by the author of the U.S. Declaration of Independence, Mr. Thomas Jefferson. How is that a negligible concern? It's coming from the person who wrote the document that provided for this Constitution ever being even considered. Anyhow, among other answers given to this, it has been upon different occasions remarked that the constitutions of several of the states are in a similar predicament. I add that New York is of the number, and yet the opposers of the new system in this state who profess an unlimited admiration for its constitution are among the most intemperate partisans of a Bill of Rights. To justify their zeal in this matter, they'll allege two things. One is that though the Constitution of New York has no Bill of Rights prefixed to it, yet it contains in the body of it various provisions in favor of particular privileges and rights, which in substance amount to the same thing. The other is that the Constitution adopts in their full extent the common and statute law of Great Britain, by which many other rights not expressed in it are equally secured. To the first I answer that the Constitution proposed by the Convention contains, as well as the Constitution of the state, a number of such provisions. We don't need a Bill of Rights because they're implied, you silly goose. Why would you want to be redundant? The general government would never want to trample on your liberties, on your God-given rights. You silly goose, you don't need a Bill of Rights, it's implied. Independent of those which relate to the structure of the government, we find the following. Article 1, Section 3, Clause 7, quote, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Section 9 of the same article, Clause 2, quote, the privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it. Do you define any of that clause? Invasion, rebellion, public safety, require. It's a whole bunch of legal ambiguity, legalese, to exploit, to optimize the subversion of God-given rights. That's it. Clause 3, quote, no bill of attainder or ex post facto law shall be passed. Clause 7, quote, no title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept of any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state. Article 3, Section 2, Clause 3, quote, the trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crime shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. Section 3 of the same article, quote, treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act, or on confession in open court. Again, how do you define any of those terms? You can't. Every time it would go to court, you would get a different definition. In Clause 3 of the same section, like comforting, adhering to their enemies, giving them aid and comfort. What is aid? What is comfort? Adhering to their enemies. What is adhering? What is enemies? What is war? Anyway, I could beat the dead horse all day, but the Anti-Federalists will make that case for everyone to see. In Clause 3 of the same section, quote, the Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. It may well be a question whether these are not, upon the whole, of equal importance with any which are to be found in the Constitution of the state. The establishment of the writ of habeas corpus, the prohibition of ex post facto laws, and the titles of nobility, to which we have no corresponding provision in our Constitution, are perhaps greater securities to liberty and republicanism than any it contains. Notice, he says republicanism, not democracy. And many of the papers preceding this one, even Hamilton overtly condemns democracy, because they always are short-lived, and when they die very sanguine. Than any it contains. The creation of crimes after the commission of the fact, or, in other words, the subjecting of men to punishment for things which, when they were done, were breaches of no law, and the practice of arbitrary imprisonments, have been, in all ages, the favorite and most formidable instruments of tyranny. You should probably take quick note of that. Arbitrary imprisonment, arbitrary levying of crimes, the creation of crimes, a favorite tool of tyranny. Definitely need to keep that on the forefront of your mind. So always ask yourself, sure, it may be illegal, but is it unconstitutional? Is anybody actually harmed? Because that's what's necessitated for a crime to actually have occurred. For harms to exist in violation of law, and not just any law, constitutional law. The observations of the judicious Blackstone in reference to the latter are well worthy of recital. Blackstone was very influential in how the founders construed their legal framework. Quote, to bereave a man of life, says he, Blackstone, or by violence to confiscate his estate without accusation or trial would be so gross and notorious an act of despotism as must at once convey the alarm of tyranny throughout the whole nation. But confinement of the person by secretly hurrying him to jail where his sufferings are unknown or forgotten is a less public, a less striking, and therefore a more dangerous engine of arbitrary government. Phenomenal quote. There are a couple things from Blackstone that are fairly contentious. That quote right there, definitely not one of them. And as a remedy for this fatal evil, he is everywhere peculiarly emphatical in his encomiums on the Habeas Corpus Act, which in one place he calls, quote, the bulwark of the British Constitution. Nothing need be said to illustrate the importance of the prohibition of titles of nobility. This may truly be denominated the cornerstone of republican government. For so long as they are excluded, there can never be serious danger that the government will be any other than that of the people. Okay. Again, Hamilton being deceitful. He's also being, I wish he could say he was being naive, but from his other writings, and we'll go over his other writings in the future, but he knew that what he was saying was uninformed. And knowing that you are intentionally propagating ill-informed information doesn't mean you're ignorant or naive. It means you're malicious, and it means you're deceitful. It means you're looking to inveigle, to use Hamilton's own words. To the second, that is, to the pretended establishment of the common and state law by the Constitution, I answer that they are expressly made subject, quote, to such alterations and provisions as the legislature shall from time to time make concerning the same. They are therefore any moment liable to repeal by the ordinary legislative power, and of course have no constitutional sanction. The only use of the Declaration was to recognize the ancient law and to remove debts which might have been occasioned by the Revolution. This consequently can be considered as no part of a Declaration of Rights, which under our constitutions must be intended as limitations of the power of the government itself. It has been several times truly remarked that bills of rights are, in their origin, stipulations between kings and their subjects, abridgments of prerogative in favor of privilege, reservations of rights not surrendered to the prince. Such was Magna Charta, obtained by the barons, sword in hand, from King John. Such were the subsequent confirmations of that charter by succeeding princes. Such was the petition of right assented to by Charles I in the beginning of his reign. Such also was the Declaration of Right presented by the Lords and Commons to the Prince of Orange in 1688, and afterwards thrown into the form of an Act of Parliament called the Bill of Rights. It is evident, therefore, that according to their primitive signification, they have no application to constitutions professedly founded upon the power of the people. Funny game. Another funny lawyer game. There's no need because the government is already oriented on the people. Yeah, well, that's what the monarchy was oriented on as well. From divine rule, and then of course from divine rule, so came the divine command of protecting the people. Then the monarch, like Hamilton is doing here, would argue, well, I think it's for the betterment of the people, and I am divinely appointed, so you can't say otherwise. That's the exact mentality that judges and justices, I put those titles both in quotes, believe today. They don't care what the law says. They don't care what the legislator legislates. They don't care. They're going to apply what they think modern times. I mean, Ruth Bader Ginsburg said it overtly. John Marshall said it overtly. Or not John Marshall. Thurgood Marshall said it overtly. The documents, the government was defective from the beginning. That's what Thurgood Marshall said. Chief Justice Thurgood Marshall. He took an oath to uphold the government which he said was defective from the beginning. That's how these people think. And Hamilton knew that. So he's intentionally misleading. It is evident, therefore, that according to their primitive signification, they have no application to constitutions professedly founded upon the power of the people and executed by their immediate representatives and servants. Here, in strictness, the people surrender nothing, and as they retain everything, they have no need of particular reservations. Quote, we, the people of the United States, to secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Here is a better recognition of popular rights than volumes of those aphorisms which make the principal figure in several of our state bills of rights, and which would sound much better in a treatise of ethics than in a constitution of government. But a minute detail of particular rights is certainly far less applicable to a constitution like that under consideration, which is merely intended to regulate the general political interests of the nation, than to a constitution which has the regulation of every species of personal and private concerns. If, therefore, the loud clamors against the plan of the convention on this score are well founded, no epithets of reprobation will be too strong for the constitution of this state. For the truth is that both of them contain all which, in relation to their objects, is reasonably to be desired. I go further and affirm that bills of rights in the sense and to the extent in which they are contended for are not only unnecessary in the proposed constitution, but would even be dangerous. They would contain various exceptions to powers not granted, and on this very account would afford a colorable pretext to claim more than were granted. For why declare that things shall not be done which there is no power to do? Why, for instance, should it be said that the liberty of the press shall not be restrained, when no power is given by which restrictions may be imposed? Listen to all these deceitful questions. If the government isn't given the power to restrict, why do you think the government would go to restrict? Because unless the government is not told specifically that it can't, It will do exactly what it's been doing today under clauses like the Commerce Clause and the Necessary and Proper Clause, and violate the terms of the Constitution to inflict its will. That's why, Hamilton, and you knew that. Well, he knew that. I'm not speaking to Hamilton. He knew that. I mean, just a few papers ago, he was talking about the human nature, the jealousy of man to constantly contend for the reins of power at all expense. Anyway, I will not contend that such a provision would confer a regulating power, but it is evident that it would furnish to men disposed to usurp a plausible pretense for claiming that power. They might urge with a semblance of reason that the Constitution ought not to be charged with the absurdity of providing against the abuse of an authority which was not given, and that the provision against restraining the liberty of the press afforded a clear implication that a power to prescribe proper regulations concerning it was intended to be vested in the national government. This may serve as a specimen of the numerous handles which would be given to the doctrine of constructive powers by the indulgence of an injudicious zeal for bills of rights. On the subject of the liberty of the press, as much as has been said, I cannot forbear adding a remark or two. In the first place, I observe that there is not a syllable concerning it in the Constitution of this state. In the next, I contend that whatever has been said about it in that of any other state amounts to nothing. What signifies a declaration that, quote, the liberty of the press shall be inviolably preserved? Y'all are going to love this next part. What is the liberty of the press? Here's exactly what the lawyers do. What is the liberty of the press? Who can give it any definition which would not leave the utmost latitude for evasion? I hold it to be impracticable. And from this I infer that its security, whatever fine declarations may be inserted in any constitution respecting it, must altogether depend on public opinion and on the general spirit of the people and of the government. So it's not set in stone. It's not a God-given right, according to Hamilton, but actually one granted by government, determined by the general spirit of the people, to use his words. And here, after all, as is intimated upon another occasion, must we seek for the only solid basis of all our rights. Wow. And here, after all, as is intimated upon another occasion, must we seek for the only solid basis of all our rights, the general spirit of the people. There remains but one other view of this matter to conclude the point. The truth is, after all the declamations we have heard, that the Constitution is itself, in every rational sense and to every useful purpose, a Bill of Rights. So absurd. The several bills of rights in Great Britain form its constitution, and conversely the constitution of each state is its Bill of Rights. Circular reasoning. And the proposed constitution, if adopted, will be the Bill of Rights of the Union. Is it one object of a Bill of Rights to declare and specify the political privileges of the citizens in the structure and administration of the government? This is done in the most ample and precise manner in the plan of the convention, comprehending various precautions for the public security, which are not to be found in any of the state constitutions. Listen to that. He is saying Articles 1 through 10 of the Bill of Rights are redundant. You don't need an express recognition from the Union government that you have a right to express yourself, free speech, free press. He says all of that is somehow, some form or fashion, some way implied in the previous 7 articles. How ridiculous is that? Yet this gentleman is the champion of modern legal education. Is another object of a Bill of Rights to define certain immunities and modes of proceeding which are relative to personal and private concerns. This, we have seen, has also been attended to in a variety of cases in the same plan. Adverting, therefore, to the substantial meaning of a Bill of Rights, it is absurd to allege that it is not to be found in the work of the Convention. It may be said that it does not go far enough, though it will not be easy to make this appear. But it can, with no propriety, be contended that there is no such thing. It certainly must be immaterial what mode is observed as to the order of declaring the rights of the citizens, as if they are to be found in any part of the instrument which establishes the government. And hence it must be apparent that much of what has been said on this subject rests merely on verbal and nominal distinctions, entirely foreign from the substance of the thing. Good grief. Another objection which has been made, and which from the frequency of its repetition, it is to be presumed is relied on, is of this nature. Quote, it is improper, say the objectors, to confer such large powers as are proposed upon the national government, because the seat of that government must of necessity be too remote from many of the states to admit of a proper knowledge on the part of the constituent of the conduct of the representative body. This argument, if it proves anything, proves that there ought to be no general government whatever. Yeah, that's why the articles were so lenient. I mean, the structure of the government that the Articles of the Confederation outlined was a friendship. That's in the preamble. It was a mutual, friendly, friend-shaped, voluntary agreement. It was very limited, very specifically binding in terms of what the articles or what that convention, what that Congress could do, the Congress under the Articles of the Confederation. Yes, that's exactly the point. For the powers which it seems to be agreed on all hands ought to be vested in the Union cannot be safely entrusted to a body which is not under every requisite control. But there are satisfactory reasons to show that the objection is in reality not well founded. Really? How about all of you individuals, all of you folks, who are now 250 years in the future? Would you say this objection isn't well founded? Hindsight, of course, is 2020, but in reality, the Anti-Federalists were warning of the exact modes of tyranny that we are experiencing today. They basically prophesied before the U.S. Constitution was ever even implemented back in 1787. There is in most of the arguments which relate to distance a palpable illusion of the imagination. What are these sources of information by which the people in Montgomery County must regulate their judgment of the conduct of the representatives in the state legislature? Of personal observation, they can have no benefit. This is confined to the citizens on the spot. They must therefore depend on the information of intelligent men in whom they confide. And how must these men obtain their information? Evidently from the complexion of public measures, from the public prints, from correspondences with their representatives and with other persons who reside at the place of their deliberations. This does not apply to Montgomery County only, but to all the counties at any considerable distance from the seat of government. It is equally evident that the same sources of information would be open to the people in retaliation to the conduct of their representatives in the general government, and the impediments to a prompt communication which distance may be supposed to create will be overbalanced by the effects of the vigilance of state governments. The executive and legislative bodies of each state will be so many sentinels over the persons employed in every department of the national administration, and as it will be in their power to adopt and pursue a regular and effectual system of intelligence, they can never be at a loss to know the behavior of those who represent their constituents in the national councils, and can readily communicate the same knowledge to the people. Their disposition to appraise the community of whatever may prejudice its interests from another quarter may be relied upon if it were only from the rivalship of power. And we may conclude with the fullest assurance that the people, through that channel, will be better informed of the conduct of their national representatives than they can be by any means they now possess of that of their state representatives. It ought also to be remembered that the citizens who inhabit the country at and near the seat of government will, in all questions that affect the general liberty and prosperity, have the same interest with those who are at a distance. Yeah. And that they will stand ready to sound the alarm when necessary, and to point out the actors in any pernicious project. The public papers will be expeditious messengers of intelligence to the most remote inhabitants of the Union. Among the many curious objections which have appeared against the proposed Constitution, the most extraordinary and the least colorable is derived from the want of some provision respecting the debts due to the United States. This has been represented as a tacit relinquishment of those debts and as a wicked contrivance to screen public defaulters. The newspapers have teemed with the most inflammatory railings on this head, yet there is nothing clearer than that the suggestion is entirely void of foundation. There's that dismissive game again. The offspring of extreme ignorance or extreme dishonesty. Good grief. What a pompous, pretentious beguiler. In addition to the remarks I have made upon the subject in another place, I shall only observe that as it is a plain dictate of common sense, so it is also an established doctrine of political law, that, quote, states neither lose any of their rights, nor are discharged from any of their obligations by a change in the form of their civil government. The last objection of any consequence which I at present recollect turns upon the article of expense. If it were even true that the adoption of the proposed government would occasion a considerable increase of expense, it would be an objection that ought to have no weight against the plan. Yeah, who cares how much money it's going to take? No big deal. We'll just, tax you to Hades and back. Yeah. You can't hate Hamilton enough. The great bulk of the citizens of America are with reason convinced that union is the basis of their political happiness. No, sir. That's why you could only get, 35 of the delegates to vote for ratifying the U.S. Constitution. 35 out of 70. Barely over half. Or no, it wasn't 35. 39. 39 delegates voted to ratify the U.S. Constitution. The Articles of the Confederation, by the way, and the second to last paragraph, requires unanimous agreement between all of the states or their delegates to amend it, let alone completely replace it. So no, the bulk of the citizens of America do not agree, are not convinced the U.S. Constitution is the way forward. They may agree that union, through the Articles of Confederation, is the basis of their political happiness, but they do not agree that the union is governed by the U.S. Constitution was the basis for their political happiness. Again, playing lawyer games. Men of sense of all parties now, there he goes again, being so demeritus, with few exceptions, agree that it cannot be preserved under the present system, nor without radical alterations, that new and extensive powers ought to be granted to the national head, and that these require a different organization of the federal government. No, that was not the popular opinion, which is why you weren't able to get the U.S. Constitution ratified. It had to be imposed. A single body being an unsafe depositary of such ample authorities. In conceding all this, the question of expense must be given up, for it is impossible with any degree of safety to narrow the foundation upon which the system is to stand. The two branches of the legislature are, in the first instance, to consist of only 65 persons, which is the same number of which Congress under the existing Confederation may be composed. It is true that this number is intended to be increased, but this is to keep pace with the progress of the population and resources of the country. It is evident that a less number would, even in the first instance, have been unsafe, and that a continuance of the present number would, in a more advanced stage of population, be a very inadequate representation of the people. Whence is the dreaded augmentation of expense to spring? One source indicated is the multiplication of offices under the new government. Let us examine this a little. It was a good examination. It is evident that the principal departments of the administration under the present government are the same which will be required under the new. Such a liar. There are now a Secretary of War, a Secretary of Foreign Affairs, a Secretary for Domestic Affairs, a Board of Treasury, consisting of 3 persons, a treasurer, assistants, clerks, etc. These officers are indispensable under any system and will suffice under the new as well as the old. As to ambassadors and other ministers and agents in foreign countries, the proposed constitution can make no other difference than to render their characters where they reside more respectable and their services more useful, i.e., more expensive. As to persons to be employed in the collection of the revenues, it is unquestionably true that these will form a very considerable addition to the number of federal officers, but it will not follow that this will occasion an increase of public expense. Yes, it will. It will be in most cases nothing more than an exchange of state for national officers. In the collection of all duties, for instance, the persons employed will be wholly of the latter description. The states individually will stand in no need of any for this purpose. What difference can it make in point of expense to pay officers of the customs appointed by the state or by the United States? There is no good reason to suppose that either the number or the salaries of the latter will be greater than those of the former. Yes, it does, because the states, it is much easier, much more personable, much more intimate for a state to go and tax its citizens than it is for a union to either tax the states like it's supposed to, or for it to try to tax the citizens. And a union, given its supposed breadth and size, is going to demand a higher expense than if the states were to do it. If the states tried to demand what the U.S. does, what the union government does from the same set of people, the state is going to get a lot more backlash than the union. Why? Because it's much easier, much more direct, much more consequential to go and protest your state government than it is to protest the union government. You can go right now to your state capital, knock on the door of your legislator, your state legislator, and have a 15 to 20-minute conversation with him or her. You try to do that in D.C., you're going back home before you ever reach the steps of Congress. He was such a liar. Where then are we to seek for those additional articles of expense which are to swell the account to the enormous size that has been represented to us? Yes, how silly. Where could this possibly come from? Don't look at the $100 trillion debt clock or the $38 trillion, whatever absurd number it is now. Don't look to that. Don't worry about that, because first and foremost, we want to provide for your safety at all expense, including indebting newborns to the tune of $200,000 before they even take their first breath. The chief item which occurs to me respects the support of the judges of the United States. I do not add the president because there is now a president of Congress whose expenses may not be far, if anything, short of those which will be incurred on account of the president of the United States. The support of the judges will clearly be an extra expense, but to what extent will depend on the particular plan which may be adopted in regard to this matter. Yeah, don't worry about the dollar amount. Don't worry about that. You're just going to have people in gowns and wielding gavels that determine your fate, demanding a high pay, a high salary. So not only are you going to pay for their salary, not only are you going to subsidize the person who is going to imprison you, but you shouldn't worry about it. We'll take care of it. But upon no reasonable plan can it amount to a sum which will be an object of material consequence. Okay. Oh, wow. I would love to say that to someone's face today and just see the immediate frustration swell up. Good gracious. Let us now see what there is to counterbalance any extra expense that may attend the establishment of the proposed government. The first thing which presents itself is that a great part of the business which now keeps Congress sitting through the year will be transacted by the president. Even the management of foreign negotiations will naturally devolve upon him according to the general principles concerted with the Senate and subject their final concurrence. Hence, it is evident that a portion of the year will suffice for the session of both the Senate and the House of Representatives. We may suppose about a fourth for the latter and a third, or perhaps half, for the former. The extra business of treaties and appointments may give this extra occupation to the Senate. From this circumstance, we may infer that, until the House of Representatives shall be increased greatly beyond its present number, there will be a considerable saving of expense from the difference between the constant session of the present and the temporary session of the future Congress. But there is another circumstance of great importance in the view of economy. The business of the United States has hitherto occupied the state legislatures as well as Congress. The latter has made requisitions which the former have had to provide for. Hence it has happened that the sessions of the state legislatures have been protracted greatly beyond what was necessary for the execution of the mere local business of the states. More than half their time has been frequently employed in matters which related to the United States. Now, the members who compose the legislatures of the several states amount to 2,000 and upwards, which number has hitherto performed what under the new system will be done in the first instance by 65 persons, and probably at no future period by above a fourth or fifth of that number. The Congress under the proposed government will do all the business of the United States themselves without the intervention of the state legislatures, who thenceforth will have only to attend to the affairs of their particular states, and will not have to sit in any proportion as long as they have heretofore done. This difference in the time of the sessions of the state legislatures will be clear gain, and will alone form an article of saving which may be regarded as an equivalent for any additional objects of expense that may be occasioned by the adoption of the new system. The result from these observations is that the sources of additional expense from the establishment of the proposed Constitution are much fewer than may have been imagined. I think I'll just have a quick image pop up of the U.S. debt clock to really drive home the point that all of these debts that would be contrived from the U.S. Constitution, they're just imaginary. They're completely void of foundation. Anyway, it may have been imagined that they are counterbalanced by considerable objects of saving, and that while it is questionable on which side the scale will preponderate, it is certain that a government less expensive would be incompetent the purposes of the Union. Excellent. So that's all Mr. Hamilton had to say in number 84. If you have any questions about what he was saying in 84, maybe questions about what was said in preceding papers, or a topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare that will, not if, but will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. Hope you enjoyed this lecture, and if not, I understand how it can be very infuriating. But if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day, and I'm not sure what the topic for the next lecture is going to be. I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, I bid you all farewell.